Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Rhysa Iris Ewonia, and today I'll be taking you through what we call co-ownership under the land tenure system of Ghana. When we talk about co-ownership, it's a situation that arises when two or more persons hold an interest in the same piece of property. Sometimes people, when they are talking about their property, they tend to think that it is an individually owned thing, or maybe it's an individually owned land or house or building. But sometimes two or more people can hold property together jointly or severally. It depends on the situation. The concept of co-ownership can arise when people jointly contribute to acquire property, or when it is granted to them either by sale or gift or by operation of law. Article 18 of the 1992 Constitution of Ghana is the basis for the concept of co-ownership because that provision speaks about the fact that an individual or two or more persons can own property jointly. Under co-ownership, there are two main types which exist. It is important to understand that although co-ownership is a common law, or it is usually attributed to the common law way of owning properties, it also exists within the Ghanaian legal space. Because Section 2 of the Land Act 2020 Act 1036 states that the allodial title can be held either by the stool or the individual, family, clan, or whatnot. So when we make mention of family, you understand that it's a group of people who are typically related by blood and they trace themselves to a particular ancestor. Based on this, you can understand that co-ownership exists within the Ghanaian land tenure space. As I stated earlier, there are two main types of co-ownership, which could either be a joint tenancy or a tenancy in common. So we are first going to talk about what a joint tenancy is and its various characteristics. Then we'll also delve into what a tenancy in common is and how it has reflected in the laws of Ghana. A joint tenancy is a situation which arises wherever two or more persons own property without any words to show that they are to take separate or distinct shares in the property. So when you convey your interest in land to a particular group of persons and you do not indicate words such as the land should be shared equally between them or separate and be distinct, typically the law assumes that it is a joint tenancy. A joint tenancy can be created in various ways. As I stated earlier, that co-ownership can be created when the law makes a presumption that it's a co-ownership, or maybe when it's a grant either by sale or by intestacy. A joint tenancy also has a similar feature. Under the common law, there's a presumption that if a property is conveyed to two or more persons without words of severance, the interest that has been created is a joint tenancy. And that was seen in the case of Finn and Gardner, and also in the case of Fenuku and John Tay. However, with the passage of the new Land Act 2020 Act 1036, this position has changed because Section 40, subsection 3 of Act 1036 says otherwise. That provision, which I will encourage you to read, when paraphrased, states that when two or more persons have been conveyed a property, it is presumed that it is a tenancy in common that has been created, unless the conveyance that transferred the interest to them expressly states that it's a joint tenancy, or by looking at the circumstances surrounding the creation of the interest in the property, it can't be presumed that it was a joint tenancy that was created. So the provision or the position of the common law is very different from what we have under the Ghanaian land tenure space. Examples of words of severance that are included in conveyances to two or more persons, which the law will presume to be a tenancy in common, include words such as in equal shares, to be divided between, equally, absolutely, or a few others. So when these words exist in the conveyance, it should give you the indication that it's a tenancy in common that has been created and not a joint tenancy. For joint tenancies, there are two main characteristics that exist under such arrangements. And if these two characteristics do not exist, then when it is a co-ownership, you can presume that it is a tenancy in common that has been created. One of the key characteristics of a joint tenancy is the right of survivorship. This right states that if one tenant dies, his interest in land passes on to the surviving joint tenant. Now, when it comes to joint tenancy, if there are maybe 5 or more persons that own a particular property and one of them dies, some will assume that his interest in the property should pass on to his heirs, which could be his children or anybody that he has specified in his will that the property should pass on to. But with joint tenancy, it is otherwise, because a key feature of joint tenancy is that when one of the tenants die, his interest in the property does not go to his heirs, but rather to the surviving tenants. So if the property that was acquired was maybe between a husband and his wife, and the law finds, or under the circumstances, it can be deduced that the nature of the property acquired was a joint tenancy. Upon the death of the husband, his interest in the property would devolve to his surviving co-tenant, which would be his wife. And this position was stated in the case of Fenuku and Jonte, of which I'll elaborate on in the later part of the video. By virtue of the fact that a joint tenancy, upon the death of a tenant, his interest passes on to a surviving tenant, it's important to understand that a joint tenant can therefore not dispose of his interest in the property to another, either by way of a will, or it cannot go to his family members or his children or anyone else through intestacy, because this flouts the basic principle of which the concept of joint tenancy underlies on. The next main characteristics of a joint tenancy is the unity of possession, interest, time, and title, which an abbreviation can be PIT, like Brad Pitt. So these unities must exist with the right of survivorship before you can confidently say that the interest that has been created in the property is a joint tenancy. Unity of possession basically means that each of the tenants must have the right to all aspects of the property. So if the property is, let's say, a rectangular shaped property, and you have leased certain parts of the property to other people, if the nature of the interest all of you have in the property is a joint tenancy, all the joint tenants are entitled to enter every single aspect of the property. You cannot create a portion out of the property and claim it to be yours and prevent the others from entering that particular part, because that is not a key feature of joint tenancy. It does not exist. If the property has been leased to people, of which the payment of rent is a key feature of leases, it's important to understand that when the rent is collected, it must be shared equally between all the joint tenants, because it is a joint tenancy. It is very important that you understand this concept, so that if, say, your parent decides to will his property to you and your siblings and makes it clear that it's a joint tenancy, if the property is a leased property, any rents that you collect from that property must be shared equally between you and your siblings. The next key feature of the unities I mentioned earlier is a unity of interest. And this unity of interest basically means that all joint tenants must have the same interest as to the extent, nature, and duration of the property. No joint tenancy can therefore exist between allodial and usufructuary holders in a piece of land. And this was stated in the case of Choka and Choka. By virtue of the fact that the nature of the co-ownership property you have created is a joint tenancy, all the interests that the co-tenants should have must be the same. So if one person has an allodial title in that property, all the co-tenants must have the allodial title. You cannot have one person being a lessee and the other person having a freehold interest and another having a usufructuary interest. It doesn't exist under the joint tenancy. So it's important for you to understand this particular principle. The next feature of the joint tenancy is a unity of title, which basically means that each joint tenant's title must be acquired through the same act, instrument, or document. As I stated earlier, a co-ownership can be created either by operation of law or by a person conveying his interest to another, or it could even be through the will. So if a property has been conveyed to you by will and it's a joint tenancy, all the co-tenants in relation to that property must have obtained their interest in that property through the same will. You cannot obtain it through a different will, nor can you obtain it through a different act. By virtue of the fact that Section 32 of Act 1036, which is the Land Act, states that you can transfer your property to another or your landed interest in another person with or without consideration. This basically means that if you transfer your interest to another person and you are intending to create a joint tenancy between that person and other people, all the people must have obtained their interest through the same conveyance or through the same document. You cannot acquire an interest in a joint tenancy property when it is not from the same instrument or document, and that is highlighting the case of ward and ward. The next unity, which I mentioned, is a unity of time. And unity of time means that each joint tenant's interest must vest at the same time or should have been acquired at the same time. So if you acquire the property on the 16th of May 2022 with other people and it is a joint tenancy, all the co-tenants must have acquired it on that particular date. You cannot acquire it on a different date or at a different time. That would not be a joint tenancy. It would be a tenancy in common under certain circumstances, which I'll explain later in the video. By virtue of the characteristics of joint tenancy that I stated earlier, you'd also know that because you can acquire property with others jointly, it is also important for you to understand that that same property can be lost by the action of you and other people. So a joint tenancy can be determined or it can come to an end by severance, which may arise in the following ways. It could be through alienation, and this is when a joint tenant alienates his potential share in the property during his lifetime to a third party. Because I stated earlier that the right of survivorship exists under joint tenancy, which in Latin is the jus accrescendi, a joint tenant can therefore not transfer any potential share he or she has in a property to a third party. However, you would understand that in certain situations, some people may not know this and they will want to transfer the property to a third party. Or even if they will not just want to, they will actually take steps to transfer it. Immediately that joint tenant does this, the joint tenant has severed the joint tenancy he has with his co-tenant. Even though that can happen, it's important for you to understand that the other co-tenants who were not part of the transaction will still be having a joint tenancy in relation to the property. But the one that transferred his interest to a third party during his lifetime would have severed the joint tenancy he or she has in relation to that particular property. This was seen in the case of Owusue Siedu and Adomako. This is because when you alienate the property, you have destroyed the unity of title. Another way in which a joint tenancy can be determined is through partition. Partition, as the word suggests, is when you divide or you decide to share the property amongst yourselves. Joint tenancy, you are supposed to enjoy or have the same interest in a particular property. But when either by the action of any of the co-tenants or by an order of a court, the parties partition the property or they divide the property into various parts, then the joint tenancy will be extinguished or it will be determined. That was in the case of Adabla and Kise. This is because partition destroys what we call the unity of possession. Unity of possession is a key feature of joint tenancy, and if that is spoiled, then clearly a joint tenancy cannot be said to exist. Another way in which a joint tenancy can be determined is when a person acquires a different interest in the property. This particular point sort of relates to the point on alienation, because when you transfer your interest in a joint tenancy to a third party during your lifetime, the third party coming in has acquired a different interest in the property. For instance, if the property was a family property and it was an allodial title that everybody was holding, and you decided to transfer your share in the property to someone else, or maybe you decided to rent it out to someone else. If you rented it out, the third party coming in is coming as a lessee. The person has a leasehold interest in relation to Section 6 of Act 1036. So that person has a different interest from the other co-tenant to the same property. By virtue of that fact, it has destroyed the joint tenancy because, as I stated earlier, unity of interest is a key feature of joint tenancy that must exist. Another way in which a joint tenancy can be determined is through homicide. This is when one of the co-tenants, either because he wants to be the sole owner of the property, decides to kill his other co-tenant to own the property. If you do that, the law will not recognize your property as a joint tenancy. And in fact, by the case of Rhysa, you will not be able to have the interest in this property because there will be no right of survivorship for the killer. The law cannot allow a criminal to benefit from his own wrong. So if you decide to kill the co-tenant to be the sole owner of the property, the right of survivorship, which exists under joint tenancy, will be extinguished and the property will no more be a joint tenancy. It will be something else. If the parties also mutually agree that they want to determine or bring the joint tenancy to an end, the joint tenancy will be said to have extinguished. And that was decided in the case of Burgess and Ronsley, which I encourage you all to read. Another way in which a joint tenancy can be determined is through the course of the conduct of the parties. If the party carries himself in such a way that it can be determined that he is no more interested in holding the property together with the others as a joint tenancy, then the joint tenancy will be said to have been determined. The next type of co-ownership which we are going to discuss is the tenancy in common. Tenancy in common is so different from joint tenancy because there's nothing like the 4 unities I mentioned, which are possession, interest, title, and time, and there's no such thing as right of survivorship. In fact, for tenancy in common, which is typically recognized under Ghana, the tenants hold the same property, but they may have different interests in the property. So if it is maybe a story building and it's a tenancy in common, the first tenant may be entitled to the first floor and the other will be to the second floor or the third floor or even the ground floor. If it's a tenancy in common, these things are the typical features that exist under this particular object. Unlike the joint tenancy, where a co-tenant cannot transfer his interest in the property to his heirs or to anyone else through a will, a tenancy in common, a tenant in the property can transfer his interest to other people. There's nothing like right of survivorship, where if you die, your interest will go to the other surviving tenant. So if it's a tenancy in common and you have an interest in that particular property, you can devise your interest in the property in a will to your children. Or even if you do not make such a will, upon your death, the PNDC law 111 will kick in and the law will decide which particular family member of yours that can have interest in the same property because it's a tenancy in common. The only unity that may exist under a tenancy in common is a unity of possession, where all the tenants are entitled to the parts of the property. But it's important to understand that because the property has been partitioned, typically under tenancy in common, it is not likely that every tenant will be entitled to every single aspect of the property. It will depend under the circumstances to determine whether all the tenants can go to every single portion of the property. A tenancy in common can be created either expressly by a sale or gifts during your lifetime, or you can do it through a will when you decide to devise your property to your children or anyone else for that matter. And that was stated in the case of Agentua and Owusu. I will encourage you all to read that case for a better understanding of what a tenancy in common is all about. A tenancy in common can be determined through partition or sale or through acquisition by one tenant of all the interests in the property. Because a tenancy in common is a co-ownership, it necessarily means that 2 or more people must have interest in the same property. So if one of the people acquires all the interest in the property, that means the tenancy in common does not exist because he's a sole owner now. So there's nothing like co-ownership he or she has with another person. Prior to the passage of the Conveyancing Decree of 1975, which has now been repealed by the passage of the Land Act 2020 Act 1036, the law presumed that when spouses acquire property, the nature of the interest they have acquired was a joint tenancy. And so, by reason of this fact, if a husband and wife decided to acquire property, and upon the death of the husband, the interest he has in the property will devolve to his wife because the wife will be the surviving tenant. And that was, as I stated earlier, seen in the case of Fenuku and Jonte. The case of Fenuku and Jonte is very interesting because it really captures the two types of co-ownership, and I really encourage you to read that case. In that case, Mr. Fenuku acquired a property sometime back in 1958, which he owned with his wife, Mrs. Fenuku. But his wife died prior to the passage of the conveyancing decree. And upon her death, Mr. Fenuku married again. And when he married, he decided to sell the property he has to his brother-in-law, which is the brother of his second wife, who in this case is the defendant. So when he sold the property to the defendant, John Tay, Mr. Fenuku passed on, and his children brought an action in court claiming that the property their parents acquired was a joint or a co-owned property between their parents, and thus it was a tenancy in common. Hence, upon the death of their mother, their father did not have the right to sell or transfer their interest in the property because they should have acquired the interest in the property and they should have been consulted with the sale to the defendant. Even though the courts agreed that the law has changed and the law now presumes the creation of a tenancy in common in relation to co-owned properties, the law recognized that the property was acquired prior to the passage of the conveyancing decree. And as I stated earlier, prior to the passage of that particular law, it was presumed that a property that has been jointly acquired was a joint tenancy, and thus the right of survivorship will exist. So because the right of survivorship was said to have existed in that particular case, the sale that Mr. Fenuku made to the defendant was right in law, because upon the death of his wife, he became the sole owner of the property, and thus he had a right to transfer it to anybody he wanted. Now, that was a decision in the case of Fenuku and Jonte. And even though the Land Act has repealed the conveyancing decree of Section 14, subsection 3, which is relevant to what we are studying today, this particular provision has been reflected under Section 40, subsection 3 of Act 1036. So the position under Section 40, subsection 3 of the Land Act 2020 Act 1036 is coterminous with that of the conveyancing decree, Section 14, subsection 3, which basically says that when two or more persons jointly acquire a property, the law presumes that it's a tenancy in common that has been created and not a joint tenancy. But it will be, because a presumption, it can be rebutted if the parties expressly stated that it was a joint tenancy they were intending to create, or under the circumstances it was a joint tenancy that can be deduced to have been created. We have discussed what co-ownership is, and we found its constitutional basis to exist under Article 18 of the 1992 Constitution of Ghana. We also stated that even though it is a common law or is typically related to common law interest in land, we also have it in the Ghanaian context, and we base this in relation to Section 2 and Section 40 of the Land Act 2020 Act 1036. We spoke about the two types of co-ownership, and we mentioned joint tenancy and the tenancy in common. And we have also highlighted that now it is presumed that when property is jointly acquired, it's a tenancy in common that has been created. Thank you for joining us today in this wonderful session. It has been lovely having you here. Please do not forget to like, comment, subscribe, and share our videos to your friends and your peers for them to learn and understand more about what the law of Ghana says in relation to co-ownership.